Hey. All present have anything to do before the Honorable the Justice of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near and give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
Morning. Good morning, everybody, and welcome to the Appeals Court session for Thursday, March 6, 2025. Your panel today is me. I'm Greg Massing. To my right is Justice Neyman. That's pronounced Neyman. People get that wrong all the time. It's Neyman. Justice Wood on my left. We have 5 cases on for today, 3 criminal and 2 civil. One of them was actually withdrawn, so we don't have 6 today. Just to really quickly go over the guidelines, each side gets 15 minutes, no rebuttal. We have read all the briefs and materials, so you can go right into your argument. We're ready for it. As I said, you have 15 minutes, but there's no penalty for finishing early. And I think that's enough of the preliminaries. So to get right started, the first case is 24P410, Commonwealth versus Brooking. I believe this is a Commonwealth appeal. Good morning.
Good morning, Your Honors, and greetings from the Berkshires. This is Jocelyn McGrath for the Commonwealth. There are just 2 areas we would like to cover in our time. One is the issue of the proper balance of responsibilities in a Rule 17 process, and the second is the subject of objection and waiver in the 2 hearings as raised by the defendant in his brief. The Commonwealth's basic claim is the simplest claim, that the first judge's order to exclude was error. A Rule 17 court summons is an evidence-gathering tool. It is not a discovery tool. It does not grant the authority, even implicitly, for any Rule 14-type sanctions. All else that follows comes from this error.
So the first judge, we're referring to her as the first judge, she made this order. Did the Commonwealth object to this?
The defendant brought that up in his brief, that because there was no explicit objection, he did not say, I object, that therefore this is waived. Our position is that Rule 22 is read broadly, and very specifically, it is sufficient that a party at the time of the ruling or order of the court is made or sought makes known to the court the action which he desires the court to take. So he did the first part. He said, Judge, I'd like a continuance. And then the defendant said, well, if he gets a continuance, I'd like to close the evidence. So the notes on Rule 22 also remind us that it is to be interpreted liberally, that it's a modern response rejecting the former rule of exceptions as being form over substance.
Is there a reason to object at that point, in the sense that there's a court order to a third party? There would be a presumption that a third party would comply with a court order that is not in the information is not in the Commonwealth's possession, custody, or control. So why would, at that point, the Commonwealth have reason to object? We
completely agree. And we also say that even if you wanted there to be an objection on the record to ease things along, the order was prospective and it was conditional. So that, therefore, it wasn't even really ripe for objection, and possibly never would be ripe. So no objection would be required at this time to preserve the issue.
Let me ask a different question. At the final hearing, the ADA represented something to the effect that Cash App, or the entity that owns it, told the clerk's office that the summons via court order was insufficient or contained insufficient information. Do we know what information was missing?
We do not, Your Honor, and that brings me to our basic...
And actually, they said that at the prior hearing as well, right?
I mean, I think the record fairly represents that the ADA went into the clerk's office at least twice. Once before after the first hearing, and then, once after the order was placed, and then another time to talk to the second judge. And basically, we believe that the proper place to put the primary responsibility to facilitate the summons would be on the court, because it was absolutely unclear. There was no actual distinct rejection or refusal to performed the summons to produce the evidence, and it was ambiguous because basically what the clerks told our ADA is that the entity said, we'll get you that information. We'll tell you what you need to give us in order to effectuate the summons. So it was a very ambiguous stalemate. There was no actual
So you put it, so the position of the DA's office was that's entirely for the clerk's office to do. We have no responsibility here to figure out what the additional information they need?
I mean, in my brief, I was mild. I said, yes, we have some cooperative kind of responsibility to help our order, but the summons is a court order, which is why it is actually better to put the responsibility on the court.
I know, I can picture the ADA walking in with a huge list of, with all the files, and they're very busy and there's lots going on, but after the hearing on, the second hearing before Judge Tyne,
The second hearing actually was before Judge Orlevitz.
Okay, the first one then.
Yes.
I mean, anyway, the one where Judge Tyne imposes the order.
September 18th, 2023.
Right. But so go put the file back and you pick it out a month later, nothing happened, right? I mean, the judges were very kind and said that it wasn't the Commonwealth's fault, but Commonwealth didn't help either.
Our position
But you need to answer that question. Answer me this question. What makes you think that you can't recharge the case and get these documents and go forward? The case is dismissed without prejudice. Why not just bring a new charge, get the documents, and go forward?
You would like me to jump to the end, that last idea that there was some evidence that in the victim's testimony?
Why can't you just recharge the case?
Why can't we just recharge the case?
Yeah, bring a new charge.
I mean,
In other words, there's a dismissal. I don't mean to interpret Justice Massing's question, but it's a very good one. And the dismissal is without prejudice.
Mm-hmm.
Why can't the Commonwealth file a new complaint, get quickly whatever evidence it needs, and bring the case? What is precluding them from doing so?
I guess this is actually very interesting. I've never seen this actual kind of, I couldn't find it in the case law, but under certain circumstances where you can't actually, we need that evidence. We need that evidence to be able to re-prosecute. And our initial, we would say that the initial error is everything flows from the initial error. But if you want to reach the idea that why didn't we recharge, it's because that critical evidence, we would not put a victim on the stand without it. And in this particular
Why
case,
can't you get the evidence?
Why
is it precluded forever?
well, it's not precluded. It's excluded, but needs to be, which is.
I mean, why would it be excluded if you brought a new complaint? Brand new case.
We are erred on the side of caution that an exclusion meant that that would be prosecutorial misconduct. And that doesn't go away.
I think you're saying, and I think you actually argued this, that your interpretation of Judge Tyne's order, the first judge's order, was that if this is not produced within 6 weeks or whatever the date certain is, it is excluded forever. That's your interpretation of her order.
And I think it's a fair interpretation of an order if it's based on an exclusion rather than, say, a preclusion.
But it's filing a new case. Can that order apply to a new case?
We actually were working on the assumption that it would, rather than hopefully sort of assuming that it wouldn't. And I think that is a fair way of interpreting what an order, a sanction, a punitive sanction would mean for the Commonwealth. If there was enough evidence on the record, which we say there wasn't.
But it's not a punitive sanction because it's dismissed without prejudice.
It was functionally not dismissed without prejudice. And actually that second order is incongruous because she tries to dismiss it without prejudice. But, basically it's...
Like suppose suppose we're not talking about documents. Suppose you're talking about witnesses. Happens all the time. You come the day of trial, your witnesses aren't there, not your fault, the case is dismissed for lack of prosecution, you can bring it again, right?
In this case, the actual evidence that was excluded was the only tangible corroborating evidence of a violation of probation. I mean, a violation of a protective order, excuse me. We believe that in that context, it is the kind of evidence that we would not put an alleged victim on the stand to say, with her testimony, I received this, something tangible, and I can only describe it, particularly in this.
Actually, what about those screenshots? Like, why can't the victim authenticate those screenshots?
Oh, my goodness. Your Honor, we are actually considering that why would we need certified records in the first place? It was the court requiring certified records in order to the court decided that.
Where is that in the record?
I have gone back through the record, and I cannot find it, because
And
it
that's
seems
not-
like there was
then
an
that's not
assumption.
I'm sorry to interrupt you, but that's not before us. So if it's not in the record.
I think what's before you would be that the defendant's attorney explained to the second judge that the first judge required certified records.
That looked wrong to me. Like,
it did look wrong to me too, but we're working off of what the first judge.
so you feel like you're bound by the first judge and by what defense counsel said?
I believe that what happened was based on what the first judge believed, and the second judge tried to explain to this. The defense counsel tried to explain to the second judge what the first judge required. But I actually don't know why. I mean, I think what you're seeing is the parties were all working under the same assumption that the first judge had the authority to do the sanction, actually had the authority to require certified records, and we disagree with both, but only one was actually developed.
Can the screenshots be properly authenticated through the victim and admitted into evidence if there were a trial?
I would love to answer that. We do believe that on the Purdy standard, that there is sufficient confirming circumstances. But in a sense, that was never developed because the idea that the judge required the certified copies was never developed. And it's, in a sense, if you give us another chance, that's probably where we're going to end up. We're probably going to argue that we don't need certified copies in this case. But it's not a bad district court record. I think there's enough here, in essence, to be able to decide the issues that are in front of the court. But you have picked up on the underlying problem that really we didn't pick up on that until a week ago. So,
by the way, you recently, yesterday, day before, filed an opposition to the motion to strike. The screenshots were never before any judge, right?
the copies of the screenshots were, and the information.
They were? Where in the record were they presented to a judge?
Well, they were provided as discovery to the defendant.
That's
and the defendant actually read them and said, oh, we have some hooks here. We'll hire an investigator because we think that we can actually use this evidence to our benefit. Because there are a couple different screenshots where he's basically discussing something with somebody about like how why his girlfriend may have actually been less than truthful.
So they were provided in discovery, but as
copies.
far as you know, that was never submitted as an exhibit at a hearing or anything like that?
No, there was no substantive hearing, Your Honors. And that really goes to how little this was developed, but we believe there's enough here for you to rule that at least that first decision was error. It was a mistake, even if you just want to put it into those terms. They were all going forward on the idea that a Rule 14 sanction was available, but she didn't have the authority and actually was in the best position to facilitate the summons. It was the court's summons. It was her clerk's office. She is the first justice of that office. She actually has supervisory power over those clerks. It would have been, and I would say that the Rule 14 amendments really do want people to work out evidentiary things so you can get to the substantive issues. We didn't have that chance.
Does a judge have a power to dismiss a case for lack of prosecution?
Oh, absolutely. But
Is that
isn't the case here.
That's not, and that wouldn't be a Rule 14 order.
For lack of prosecution, usually is a Rule 14 order. In my understanding. I mean, it can be, like, in the sense that, it is a sanction for not getting the evidence to late produced discovery, certainly.
But drilling down on that, I mean, what I think actually happened here at the moment of dismissal was the judge asked, can you, Commonwealth, prove your case? The Commonwealth didn't say we null pros. They didn't say we move to dismiss. The Commonwealth said, well, that would be a he said, she said, and that would be a hard case to make, and then the judge seemed to just dismiss the case. And I think what we're all, well, at least what I'm struggling with is, can a judge in that ambiguous context make the decision to dismiss the case? The Commonwealth is saying, we could make the case, but we don't want to, but we're not moving to dismiss. Is that an accurate characterization of the record? And if it is, does the judge have authority in that moment, on that ambiguous record, to dismiss the charges?
I think that's a very thoughtful, the discernment that even the judge should have been able to say, look, there is something to go forward on. And then, Commonwealth, you've got to work this out. You think about it. Are you going to go forward with this case? But there really was, I would say, probably a practical, district court is very practical, a very practical understanding that in this type of case in particular, we don't go forward. We don't put an alleged victim on the stand without corroborating evidence.
Well, then, more simply, who ended the case?
Right.
Well, I'm asking, who ended the case? The judge or the prosecution?
Well, the judge, I mean, we can't dismiss for our own lack of prosecution. It's an oxymoron. I mean, I think that...
You could file a null pros, though.
That is our type of...
And you did not do that?
We refused to, yes.
Okay.
Final question for me. I'm going to ask this. It's really Justice Massing's question. I'm going to ask this again. What is precluding you, in light of the fact there was a dismissal without prejudice, from bringing the case again and proving the case through the victim's testimony in the screenshots, assuming that the judge's order did not preclude that? What legally is precluding you from doing that?
Nothing.
And Attorney Carosi, you're going to get the same question, so coming attractions.
I agree. We could have put
Well,
this...
it's not, I'm not saying, I'm asking, I'm not saying.
No, I understand the distinction, and I'm not going to stand on that. I think we did have the victim's testimony, and I think there's a way of saying something is functionally too weak to put forward, and that's what.
Are you saying it's the Commonwealth would not go forward based on the victim's testimony and the screenshots alone? Is that what you're telling us?
That's what we. I mean, I can't make that decision, and I don't see that decision actually being made on the record. But I know that that would be very, very hard for us to do, and we would likely, which I think the ADA functionally said, we don't put forward he said, she said cases very lightly. I mean, I guess we'd have to go back to the victim. Perhaps it was even like it was
Not a he said, she said case if you have corroborating screenshots of evidence.
So if we had the screenshots, no, of course. But the thing is,
My question presupposed that the judge did not exclude the screenshots.
You're right, Your Honor. I'm sorry. I was off on another track.
Look, your time is up. I need an answer. Is there anything precluding the Commonwealth from bringing the case on the basis I just stated?
If the judge didn't exclude it again, no.
Okay. Thank you.
Thank you, Your Honors.
Good morning, Your Honors, if it please the Court. I'll start with Justice Neyman's recent question.
Oh, it's still Neyman.
Neyman. I knew I was going to mess it up. I knew it. I said I shouldn't say it, but I did anyway.
I usually get a lot worse than that, so it's okay.
So the Commonwealth, I think they conceded that they could have gone forward with the screenshots. And in fact, they were required to go forward here. They chose not to choose a trial.
Is there anything precluding the Commonwealth
Absolutely
right
not.
now from refiling the case and trying the case with the victim's testimony and the screenshots, assuming the judge were to allow the screenshots into evidence and they were properly authenticated? Could the case be brought?
It absolutely could. It absolutely could. And I think that that's somewhat fatal to the Commonwealth's argument that this was a dismissal with prejudice.
And just to add on to that,
Yes.
Is there anything precluding them from using Cash App documents if they get them?
I don't think so. I think if they were to recharge, if they were to refile and they were to get the records, perhaps the court might tell them that it's the law of the case or something and that they can't use it because of the prior order. But we don't have that here. We don't have that on this record.
Would the defendant, if it was recharged, would the defendant argue that that ruling from the first case is binding now?
This I don't know. I'm not his trial attorney. I'm not sure what the trial attorney was. Candidly, they may. I think that there's definitely a chance that they may argue that, but that's a question for the court as to whether or not that's the law of the case. And then that would have been the proper procedure to get the Commonwealth here in front of this court, would be to do precisely that, to get an actual order. Recharge, refile, get an order that they can't use it, and then they can come forward. And then the kicker there is if they were to do that, this court would have the benefit of the actual records that they're complaining about being excluded. And I think that that's fatal to the Commonwealth's appeal here. They're asking this court to decide that they were prejudiced from the exclusion of these records, but nobody knows what those records would have contained. And
Sorry, I apologize. I may have missed the step. But if the court takes the view, well, if the defense challenges, if we refile the case, the Commonwealth files a new Rule 17, and the defense stands up and says, no, you can't do that because with law of the case, Judge Tynes said that this is forever banned, you're not going to, and the judge you're in front of agrees with that, you're not going to get the records because the judge is not going to issue the Rule 17 order. So in that situation, you don't have the records to flesh out. Am I right about that?
Under that scenario, that would be correct. And I think that the Commonwealth could take up a 211.3 at that point and ask the court for relief on the Rule 17, and they could get it.
Right, but the defense could also not object, but you're saying fairly, I'm not in the, it's premature to ask me to do that. I get it. Okay, sorry.
And I think that the crux of the issue here is really, what would the records have shown? Would they ever get them? We have no idea. And I think it is important to note that, and I understand that the case was dismissed, but the records never arrived in the clerk's office. The record was transmitted to this court in April of last year, and the docket reflects that those records were never received. So the Commonwealth can't show that they ever would have received the records. And even if they could, they can't show that those records were material. We don't know what they would have shown. We don't know if they would have contained anything relevant. We don't know if they would have contained anything admissible. And candidly, they may have exonerated Mr. Brooking. If we're going to speculate about what's in there, they could have exonerated him. They could have shown that the account was registered to somebody else. It could have shown location data with respect to where these messages were sent from, and it might have shown that it was sent from the state of Florida or somewhere where Mr. Brooking wasn't. So the Commonwealth takes this position that this was their sole evidence in the case, and they couldn't go forward without it. And it's entirely speculative. Nobody knows what's in there. So
let's drill down on Judge Tynes' order.
Yes.
What authorizes a judge to exclude evidence from a third-party court order when the evidence is not in the Commonwealth's possession, custody, or control?
I think Rule 17 itself permits that. Now, I would suggest that
What part of Rule 17?
So Rule 17 provides the authority to the court to set a date on which the records need to be returned, and that's a date that is a reasonable period of time prior to trial. And the Jake J. case, which I cite in my brief, states that if a statute gives a court authority to order something, it implicitly gives them the order to issue sanctions to enforce that order.
Right, but the sanction should be against the party who's not complying, which is, in this case, the third party, not the Commonwealth, let me reframe that. What did the Commonwealth do wrong to deserve a sanction?
I think what the Commonwealth did wrong to do a sanction, to deserve a sanction, is that they did absolutely nothing. They got this Rule 17 issued, and they did absolutely nothing to get the records.
But number one, it's a court order.
It
Number
is.
two, the Commonwealth had on the proposed court order, on the summons, in order to produce the records to the DA's office and to the clerk's office, the judge crossed off to the DA's office and said, no, it's just going to the clerk's office. So number one, it's a court order. Number two, it's only provided to the clerk's office. The judge took it out of the Commonwealth's hands.
Well, I don't think that the judge took it out of the Commonwealth's hands. I think that was where the documents were to be sent to, and I would suggest to the court that it is standard for it only to be sent to the clerk's office. That's pretty standard protocol, that it doesn't get sent to multiple locations, it doesn't get sent to the district attorney's office, but that didn't remove the authority from them to pick up the phone and contact the third-party carrier and say, what is the information that you need for us to...
Sorry, who's them? The them is the Commonwealth?
Sorry, for the Commonwealth, because this is...
You said the authority of the Commonwealth to do ... They don't have authority, I mean, they have the same authority anybody has in that, but it's not their order. That's Justice Neyman's point. It's not their order. If anybody has an obligation, as opposed to authority, if anybody has an obligation to seek enforcement of the order, it seems that it's the court or the clerk's office working for the court, not one of the parties. Do you agree with that?
I agree with that, but the issue is that this is the Commonwealth's evidence that they want, and they claim that it was their sole evidence. They claim that it was the only thing that they needed to go forward at trial, and they made no effort to get it. There's nothing preventing the Commonwealth from calling Cash App, from calling the third-party record holder and saying, You've told us that you need additional information to comply with this summons. What is that additional information? And instead, on September 18th, they reported to the court what I just said. They're going to tell the clerk's office at some point what information that they need, and the clerk's office is going to tell us, and we'll refile the Rule 17. And a month and a half later, after the second deadline has passed, they have the same report. Well, we're still waiting on information from the third-party record carrier. A month and a half later, there's sole evidence. We're talking 7.5 months after the complaint issue. There's sole evidence in the case, and they haven't picked up the phone and made a phone call? So I think that the court has authority.
What did the clerk's office do? It's a court order.
And perhaps the clerk's office could have done that, but this is a situation where they're complaining about the exclusion of the record because it's their sole evidence, and they didn't try to get it.
The second judge made a finding on the record that the Commonwealth acted in good faith.
I understand.
No transgression by the Commonwealth. The Commonwealth did its earnest level best to compel production of records. They're not at fault. It's the fault of the third party that failed to comply and that the Commonwealth had not engaged in dilatory behavior. Give me a case where a judge has made such a finding and yet still dismissed, or rather still excluded evidence of a third party production.
Judge, I have not found a case analogous to this situation. I have not. There are cases in the Rule 14 context.
So the evidence is out of the Commonwealth's possession, custody, or control. The Commonwealth did everything it could to get it according to the judge's finding, and the judge said the evidence is still out. That would be pretty bad precedent, it seems to me.
Well, I think that this is a situation where the court has to balance the defendant's rights to a trial.
Was this case nearing its Rule 36 time?
It was not nearing its Rule 36 time, to my understanding.
5-month-old case?
It was 7.5 months old, I think, at that point. It's a situation where, again, the Commonwealth is saying this is our sole evidence, and the defendant is sitting there 7.5 months later and doesn't even have the sole evidence in the case. And
Remind me, was the defendant in custody?
He was not in custody, no.
Okay.
No.
Sorry. Go ahead.
But I would suggest to the court that there is authority to enforce that order, and I don't think that there's anything that says that Rule 17, that the only remedy, that the only enforcement that the court has is a motion to compel.
Give me your best case in the context of a third-party order that suggests the court has this authority.
Judge, I did not find a single case where this issue has been raised one way or the other. I have not found a case where the court has said that they cannot issue this type of sanction, and I have not found a case where they have said that they can. And this may be that case.
As a sort of stepping back as a policy matter, you as defense lawyers need Rule 17 to get documents from third parties as well. Don't you think it would be helpful to clarify that when a Rule 17 order issues from the court, that it's the court's responsibility with the court's authority and the court's resources in the clerk's office to see that its own orders are enforced for the benefit of both parties, or all parties who are coming before the court, not just in criminal cases, but anytime a party, such as a criminal defendant, wants evidence and they want the court's authority to enforce that order, wouldn't it be in your interest as much as everybody else's that be the articulation of the rule here?
It may be, but then you're putting the entire burden on a busy clerk's office to receive this when you have a party who specifically wants it and claims to need it, who is not doing anything to try to get it. And I think that that's the crux of the issue here, is that we have a situation where they've gotten a continuance, they want a second continuance, the court's not going to give them a second continuance. So I think looking at it the other way is what would have happened if he didn't exclude the records. The next date was for trial. He was not giving the Commonwealth a further continuance. If he didn't exclude the records, that means that, well, we can wait and see if the records come in between the final pretrial conference date and the trial date, and we'll hash it out at trial whether or not they come in. And the record shows that they wouldn't have come in. And so I think that that's part of the problem. So what was the court to do here? To give the Commonwealth infinite continuances in order to get these records? I think that's the crux of the issue.
Isn't it fair to say it's a problem of the court's creation? In other words, the court set this deadline. The court didn't apparently instruct the clerk's office to find out what more information Block needed. The court didn't, for example, inform the clerk to issue a contempt hearing summons to Block's general counsel and say, please come in on a date certain and explain to us what you need, or we will determine whether or not to hold you in contempt. Instead, the court, it seems, just set this deadline and said, if the records are not here, I'm excluding them. Why is it anybody's fault other than the court's fault for creating this mess?
I think I just circle back to the point I've made, which is that it is also the Commonwealth's fault. They wanted these records and they chose not to act. And I appreciate the court's concern that perhaps the court and the clerk's office could have done more. But if the Commonwealth is going to complain about a ruling that they did not object to,
Is it appropriate for the Commonwealth to reach, when there is a court order, would it be appropriate for either party to reach out to the subject of the court order on their own and say, hey, give us X, or why aren't you doing Y? Once there's a court order, doesn't the court essentially, it's the entity that has responsibility and control of the issue. I don't know that a court would be okay with either party reinterpreting a court order or telling a party how to, telling a non-party or third party how to respond to a court order. That strikes me as problematic.
well, here, it's a little bit different, I think, because they actually, the third party communicated to the clerk's office that they needed additional information in order to comply. They said, we can't comply with this based on how it's written. We need additional information. And so in that point, it's incumbent to find out what that additional information is. And if the Commonwealth knows that the clerk's office is not doing it, I would suggest it is incumbent on them to do it. And I would note that I don't think that there's any prohibition on somebody reaching out to a third-party record holder to inquire about the status of their production of records. And one point I just would be remiss if I didn't bring up, and I know it was discussed briefly with the Commonwealth, is that these issues are waived. They did not object to any of this. And the court raised the question of whether or not it was necessary to object when the order was initially made by Judge Tyne, and I would suggest that the answer to that is yes. The Commonwealth's response was, well, let's not read the rule too literally. We clearly weren't happy with this decision. But the way that it played out was they asked for a continuance. The court said, you're not getting a continuance. Well, the court said, okay, I'll give you a continuance, but I'm not going to give you any further continuances, and the records will be excluded.
Under Yasin, we have the authority to take this case if it's of a certain level of importance, as Justice Wood suggested. Do you agree or disagree that this case rises to that level?
I don't know that it rises to that level, but one point that I would note is that even if it does rise to that level, Yasin or Yasin, however it's pronounced, also says that you can only consider it if it's to uphold the lower court's decision. So even if it is a matter of paramount public importance, the court can only consider it if it's going to uphold the lower court's decision. And then the other caveat is that even then, the court can only do that if the record is sufficiently developed to allow analysis of the issue. And here, it is simply not. In part because the Commonwealth didn't object, and that deprived anybody of the opportunity of making an argument about the propriety of these orders, but also because we don't have the records. And I think that that's fatal to the entire analysis, because even if the court is to find that it was error to exclude these records, how can the court find that there was prejudice? We don't know what the records would have shown. We don't know if they would have helped the Commonwealth's case. We don't know if they would have completely sunk the Commonwealth's case.
Well, isn't prejudice irrelevant at this point based on the fact that the dismissal was without prejudice?
I'm not sure I understand.
Well, prejudice only comes in if the Commonwealth were to bring the case again and the judge were to exclude everything, including the screenshots, it seems to me.
Well, I think that the court always has to undergo a prejudicial error analysis. I think the court has to first decide whether or not it was error to exclude the records. And if the court is going to give the Commonwealth relief for that error, it has to find that they were somehow prejudiced from the error. I don't think that they're immune from having to show prejudice because it was dismissed without prejudice. They have to establish to the court that it would have...
You're saying separate and apart
separate type of
from
prejudice,
a new
yes.
complaint. Got it.
Yes. So the question is simply, would it have made a difference? If they got the records, they have to establish that these would have been material. And that's, I think, that the crux of the issue is. It looks like I'm out of time if there's any further questions.
I think we understand it. We'll argue both sides, and case is submitted.
Thank you.
Next, we'll be hearing 24P467, Commonwealth versus Boutet or Boutet. You can maybe, Boutet.
Yeah, just get a glass.
before you begin, I assume there's no relationship between you and Matthew Peterson, the trial
There's not,
attorney?
Your Honor.
Okay.
There's not. I am related to several attorneys who are Petersons. This is not one of them.
Okay. Thank you.
Good morning, Your Honors. May it please the Court. My name is Attorney Kim Peterson. I represent the appellant defendant in this matter, Kevin Boutet. There's an old English proverb that says, you can't unscramble an egg. And this case is an entire omelet. And I know Your Honors have read the transcripts. You're familiar with the record. This is replete with why Commonwealth versus Love should be upheld.
So shouldn't you have given that advice to trial counsel when he asked for this proceeding?
Wouldn't that have been wonderful, Your Honor?
I mean, we had this problem with the last case. I've got a similar problem in this case. This was exactly what the defendant asked for, and it didn't work out, and now you're here saying, well, we asked for it, but can we start over?
Mm-hmm. The difference between this case, Your Honor, and the prior case, Your Honor, is the defendant's due process rights completely violated in this case. And as you can tell from reading the 135-page transcript, you cannot tell what comes in as a motion and what comes in at a trial. The lower court judge, who is a very good judge, even says over and over again, should we be doing this? This doesn't seem right to me.
Right, but defense, to restate the question, defense counsel says, yes, please. And it's not, and I think it's more than that he's now unhappy with the result. I actually think, at least from my reading, he got exactly what he wanted. I mean, you got to get into the weeds and I don't want to take too long, but his pickle was, correct me if I'm wrong, that he was being held without bail in this case because he had been arrested in a new Superior Court case. So he could not get out of jail on this case unless and until he got this case resolved. He got this case resolved with probation and then was free to go back to Superior Court on his 58A and challenge his hold on 58A. So he got exactly what he wanted out of this. And so now you're saying undo it because of due process violations.
That's correct, Your Honor.
Okay.
Because Commonwealth versus Love says these two matters must not be combined, must not. Right. And it was up to the judge to say, you know what, hold the horses. I don't care what your client wants. It's wrong. And it's so wrong for this very reason. Because as we go through it...
Judge Hillman knew the name of the case.
Yes.
He knew
it and didn't go back in his lobby and say, hey, let me check this out. Let me see what this actually says from 2008 that supersedes the Powell case, which is an appeals court case. It supersedes it. And I think
the Powell case was also pretty negative about the procedure, but the question is, and I think isn't the question correct, that at best we look at this under the substantial risk of a miscarriage of justice.
At best, Your Honor.
Right.
However, that doesn't negate, as you know, going through the transcript as well as this is a very convoluted case to even read. And not to jump to argument 3, but the Commonwealth hangs their hat on sufficiency of the evidence because one of the officers spoke to the mother of the defendant who said that the victim in the restraining order was the one that called dispatch to say dispatch had the restraining order with her name on it. That's on page 29 of the transcript. That wasn't allowed in it. That was only allowed in at the motion, not the trial, yet the Commonwealth is hanging their hat on that. That's the problem with this case.
Sorry.
No, go ahead.
I think what you're saying is the texts to the central claim of violation of the restraining order that the defendant texted Jennifer, his ex-girlfriend, is corroborated only by that mess that you just went through. That's what you're saying, right?
That's if we skip to argument 3, and I do not mean to do this, but this is where we get into the weeds with this kind of case. The Commonwealth is going to say that there's sufficient evidence because Jennifer Cognac was mentioned. That was not allowed as to the trial part on page 29.
But I mean, also the defendant says that I texted my girlfriend Jessica.
But that's all he says. And then the Commonwealth introduces
so what, he didn't say, he didn't say her
just
last...
have a phone number on it. There's no, they never get the records to show who it belongs to. They never show what the date is on it, that this was this Jessica. He could have had a girlfriend in the past. He could have had one in the future. The restraining order is 10 years old. Doesn't say in the restraining order what their relationship is, whether they were roommates, whether they're, brother and sister. It doesn't say in the restraining order. This could be any Jennifer. And even the substance of those texts aren't something like, I know I shouldn't be contacting you, or I know you have a restraining order against me. It doesn't say any of that. Does it show some shame? Yeah, but who knows what kind of shame that is? That is the problem with this.
Go back to Justice Massing's question, please.
Yes, Your Honor.
Would you agree this is reviewed for substantial risk of a miscarriage of justice?
To some, Your Honor. Some of them the defendant does object to. And it is in my brief. Some of the questions that he objects to consist of the line of questioning, like we were just talking about, what dispatch tells the officer regarding the restraining.
Right, but that's as to, those are evidentiary issues. The overarching issue is whether or not the judge erred in combining the processes, right?
Oh, absolutely.
And is that reviewed for substantial risk?
Yes, I do believe that, Your Honor. I believe I argue that in my brief as well.
So Powell's a case where they found no substantial risk, and Healy, issued right after Love, is an SJC case where they use the same language, don't use this process. However, they found harmless error in that case.
I would say this is more than Healy. And if Your Honors have read it, which I know you have, the 135 pages, it is so convoluted and so messed up. And I list in my brief all the different pages that it is really difficult. And I've been doing this for 30 years. This is the most difficult transcript I have ever read, to figure out what is the motion, what is the trial, and what is both.
You don't claim anywhere in your brief, as far as I can tell, that the judge's findings of fact on the motion to suppress are clearly erroneous. Am I correct?
I don't, Your Honor. The whole problem with this is, right, again, this is not in the right order, as I argue in my brief as well. They go through the whole motion/trial, and then the Commonwealth rests. The defendant goes after not guilty, a not guilty at the close of the Commonwealth's evidence. Judge cites the Lattimore standard. That gets done. Defendant goes, well, I'm just going to rest now.
Oh, we're aware of the order.
Yeah, they rest, renews that. The judge again cites the Lattimore standard, takes a break, takes a recess, comes back, and now they do the motion. Now they do the motion, and they both get closing statements and they get to argue humane practice rule now for the motion to suppress. I mean, that is blatantly against Commonwealth versus Love. I mean, even
I think we can stipulate that this is blatantly against Commonwealth versus Love.
Well, that just takes out a lot of my argument, Your Honor. Thank you. You have two specific. I mean, I think we do have to drill down on whether we think there's a substantial risk of a due process violation, miscarriage of justice here. And so you raised two issues. I mean, actually, you raised one really that the overlap is that the Miranda and the invocation of Miranda is perhaps used against your client. And could you clarify what your argument is there? I mean, I think it's the invocation and the wanting to talk to a lawyer. Yes, Your Honor.
It's not the fact that the Miranda card gets in. That's.
Well, I mean, I think that heightens it. Quite frankly, I think that was overly prejudicial without.
Why? Why?
I mean, well, because 11 times the Commonwealth brings up the Miranda issue. And I understand that it goes to the humane practice rule. So it goes to the motion part. But it comes in for everything. And defense counsel did not object, so it's a substantial risk of miscarriage of justice.
And it's a bench trial.
And it's a bench trial, so we assume that the judge is going to know the rules of evidence and what he's going to let in and what not let in. But as to your point, Your Honor, I think it just shows the inherent danger of combining these two motions, because the merits are not going to be weighed evenly. And the problem becomes it's overly prejudicial to my client. And I understand that they're going to say, well, it's kind of a consciousness of guilt thing because, he says, I'm going to talk to an attorney, and then he goes on his phone and he starts deleting messages. But then when he's in the hospital, the officer again testifies, well, I don't talk to him because he invoked his right to counsel. That's overly prejudicial. There was no need for that, even before the judge. There's no need for that. There's no need for putting the card in. We all get the idea. The idea is that it was voluntary statements. But to overkill it, I think, is another indication how the intertwining is just unduly prejudicial.
I want to press on this prejudice under the substantial risk of miscarriage of justice standard, and very specifically on the facts. The police show up because there's a 911 call, and please correct me if I get any of this wrong. And it's clear that the 911 call comes from the defendant's mother, and the defendant's mother is very upset. And I think it's a fair inference that given the defendant has admitted that he is texting Jennifer about the taking his melatonin or something, his pills, that he called, and this is the question I really have. Is it a fair inference that he texted Jennifer, Jennifer contacted his mother called 911 and then shows up very, very upset thinking her son is going to hurt himself? And all of that supports a reasonable inference that the Jennifer he texted was the woman who has a restraining order against him. You're saying that's not reasonable? And that there's a substantial risk of a miscarriage of justice?
I guess this is the problem, Your Honor. Are you talking about the motion or the trial? Because some of that information doesn't come in at the trial.
What specifically, that would be helpful, what specifically from that train of evidence did the judge rule is inadmissible at trial? He
would not allow in, the defense counsel objected, and the judge said, okay, this line of testimony is not coming in, page 29. And what does not come in is that the mother tells the officer that the ex-girlfriend sent her text messages and screenshots. Now, the officer then, and again, we're going to go back to argument 3, when he's pressed by the Commonwealth, don't use pronouns, says, when they're saying he and she, the Commonwealth says, hey, step back, let's not use pronouns. And he said Jennifer, and it's on page 30. Jennifer Konak, with a question mark. In other words, he doesn't even know the last name of the alleged person sending the mother. So that comes in at motion, not trial.
Thank you.
Thank you. And Your Honor, I will say this is a case that was. I looked at the docket. This matter was tried from 11:05 to 1 p.m. The judge recessed and then came back from 1 to 2, from 2 to 2 to something. This wasn't even a 3-hour matter. You know, it's not going to impede the Commonwealth for this to get put back on the trial list. The Commonwealth's duty, and I was a prior ADA, is to seek justice. And reading this transcript, it is not justice. That is what the defendant asked for. He asked just for a fair shot at this. And if there are no more questions, I will rest on my brief. Thank you, Your Honor.
Attorney Kosh, welcome or welcome back. Is this your first time arguing or here?
Second time.
Second time. Welcome back.
Thank you. Good morning, Your Honors. May it please the Court, Kyra Kosh, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. To start with the first issue, the combined proceedings, it was the defendant who initially requested that the proceedings be combined. And as Justice Wood pointed out, this was to the defendant's benefit. He got exactly what he wanted because...
Could you explain with great particularity precisely what was the benefit to the defendant in having this dual proceeding?
The benefit was that he would be able to seek his pretrial release, as his bail was revoked on this case, as he was arraigned the week prior, and he was held under 58A on that case, and his bail was revoked on this case. Now, as it's said in the record, you cannot appeal a bail revocation, but you can appeal a 58A, whether you go to Superior Court for a bail review hearing or you reopen the 58A. So he wouldn't have no chance of pretrial release if this case was not resolved that day. And the defendant did not want to waive his rights to pursue the motion to suppress, and he did not want to waive his right to a trial. So he said, let's just do it all at once.
Can I ask, drilling down on that, why the Love is very clear about the right way to do this, do them sequentially. Why? And there's some indication in the record that defense counsel is really busy. He's got to get to Suffolk Superior. I mean,
correct.
I get it. But given that we're talking about a constitutional requirement, they could have done this sequentially. It would have taken a little bit more time. Maybe he wouldn't have gotten to the call at Suffolk Superior, but in that situation, I think he's supposed to say to Suffolk Superior, sorry, I can't get there. In other words, it could have been done that day, and defense could have gotten what they wanted constitutionally. Is that wrong?
Correct. It could have been done that way, and it should have. But the question is whether there was a substantial risk of a miscarriage of justice from the proceedings being combined, and whether it was a due process violation. And if you look at Powell, it is the only case that specifically addresses whether it was a due process violation. And in that case, they said there was no due process violation. Even in that case, it was the judge's suggestion that the proceedings be combined, whereas here it was the defendant who continued to request the proceedings be combined. It was not due to the judge's suggestion or some urgence by the prosecutor. Both of them were very hesitant and cautious to proceed in this manner, but it was the defendant who kept saying, let's do this, let's do this. And the judge conducted a colloquy specific to the combined proceedings, saying, you understand that I'm going to hear testimony that may not be admissible at trial, and I'm going to hear it all together. You understand that? And the defendant said, right. And he was afforded the opportunity to speak to his lawyer off the record, and defense counsel said he also spoke to his client before this happened, saying, you're sure this is how you want to proceed? And the defendant continued to say yes. So for that reason, there was no due process violation and a substantial risk. The judge continued to express his confidence in parsing the issues, and the defendant did so. And when you do look at the transcript, I didn't find it all that confusing. I only found two pieces of testimony that defense counsel objected to for purposes of trial. And there were two objections made by the Commonwealth. The two objections by defense counsel were to defendant's mother's hearsay statements to the officers and the fact that the hospital discharged the defendant in good health.
Can we start with the first one? There's a footnote in your brief that says it's not hearsay, but I don't know if you followed up on that. Is it, what's the...
That was a vestigial argument that I forgot to take out of my brief. The prosecutor below conceded it was hearsay, so my hands are tied there. So I apologize for that. That was an error in editing. So the hearsay statements by the mother and the fact that the hospital discharged the defendant in good health. That is the only evidence that was not admitted for trial apart for trial. Everything else was admitted for trial.
So what was the sufficient evidence that the messages were sent to a phone number that belonged to the plaintiff in this case?
So the evidence the judge expressly stated when he was declaring the verdict he said, I don't have any reasonable doubt that the defendant sent the text message to the restraining order plaintiff, this is transcript site 125, based on the content of the text messages themselves. When you look at it, the defendant says, I'm sorry, Jessica, I love you, my sweet baby, et cetera, et cetera. And you can see the text messages from the recipient saying, well, I'm calling the police, I'm calling the ambulance, and I'm sending these texts to your mother because you get mad every time I call the police. There's also the several statements he made to the police where he admitted to texting Jessica, his ex-girlfriend, and that he didn't mean what he was saying, that he didn't actually try to commit suicide. And there, you can also look at the restraining order itself, which was admitted as an exhibit. But also there's the consciousness of guilt evidence, not only the defendant's ruse request to speak to an attorney, but also his initial denial of sending text messages to anyone, let alone the restraining order plaintiff. And there's also the statement by Officer Cuccio testified that dispatch had told him that there was an active restraining order between the defendant and the ex-girlfriend who said she received the text messages saying that he was going to kill himself. Now, while this is hearsay, no one objected to this, so the judge was entitled to consider it for its full evidentiary value. So for that reason, there was sufficient evidence that it was the restraining order plaintiff who the defendant sent the text messages to.
That last piece, I got to go back and look at that. I take your point. I think that might be dispositive. But the first piece, Jessica, just for the heck of it, how do we know, is it substantial risk of miscarriage of justice that it's a possibility that it's a different Jessica?
There may be a possibility, but I don't think it's beyond a reasonable doubt, and that's not what the judge concluded.
Yeah.
And the Lattimore standard is very low, of course, and the evidence must be viewed in the light most favorable to the Commonwealth. So for that reason, there was sufficient evidence. And just for the last issue, there was also no substantial risk of a miscarriage of justice from the admission of any Miranda evidence because there was a humane practice issue that was live for trial. And the fact finder may hear evidence that the defendant was informed of and understood his Miranda rights under the humane practice doctrine. And the prosecutor wasn't arguing the forbidden argument that, oh, he only requested an attorney because he's guilty. No, the argument was that the defendant requested an attorney as a ruse to delete inculpatory evidence. That was consciousness of guilt evidence, not the he's guilty because he requested an attorney and invoked his right to silence because he's guilty. There's no Doyle issue. And again, this is a bench trial, so this court presumes that the judge correctly applied the law. And when you look at his findings and determination on the voluntariness issue for the motion to suppress, it's very clear that he was properly self-instructed as to the law.
Can I go back to Officer Cuccio's, if I said that correctly, hearsay, relaying hearsay from dispatcher that he's got there's a restraining order of the ex-girlfriend. Is there an argument that this is precisely the problem with Love? This is, I think for the reasons you articulated very well, really important evidence of guilt. And it's hearsay. It shouldn't come in at trial, but it could come in at a motion to suppress. And I understand your point, there was no objection, but is that precisely why we don't allow this? And was it in fact, well, what's your argument as to why this is effectively a Love, prejudicial error under Love?
I don't think it's necessarily that this evidence was admitted necessarily because the proceedings were combined. Even in a regular trial, hearsay gets admitted, there are no objections made. The burden is on defense counsel to object when hearsay is admitted. And it was, if you look at this point in the transcript, there wasn't confusing things happening, it was just normal testimony, and it was admitted. I don't think it's because the proceedings were combined that that evidence was admitted. There's just really no support in the record for that.
Thank you.
So if this court has no further questions.
One question. So,
Sure.
I mean, Judge Hillman was aware of the Love case and went ahead anyway. And really, this procedure shouldn't happen, right? I mean, the SJC has made it clear this is not supposed to happen.
Correct.
So how do we enforce that rule if we say that, well, it's okay here?
Well, if you look at the cases, Powell, Love, and Healy, they say no substantial risk of a miscarriage of justice from the fact that the proceedings were combined. And there's also here, we have the colloquy of the defendant by the judge. We have the defendant is the one who requested this and continued to request it. He made the informed decision to do so. It was to his benefit.
But I mean, but we don't want to suggest that that you should do that. The judge should accede to that request.
Of course, this should not have happened. I'm not saying that there was no error here. I'm just saying there was no substantial risk of a miscarriage of justice. This trial was fair to the defendant, although combined proceedings may have the potential to cause confusion as to the testimony. Again, I don't think it really is that confusing when it boils down to which objections were made and which evidence was admitted. And the judge continued to self-instruct him on the record, okay, I will consider this evidence solely for the motion to suppress and not for trial. So for that reason, I would say there's no substantial risk.
Okay. Well, thank you both. Another really interesting case. It's submitted. And I think we will take a break after this third one. So we're going to hear one more case, and then we'll take our customary break at around 11 for 15 minutes. So for cases 4 and 5, you can plan to start on that about 11:15. Third case, 24P378, Commonwealth versus Sigman.
Good morning, may it please the court. My name is William Corman, and I represent the defendant in this particular matter. I think it's fair to say this case has sort of taken a left turn from where we originally were when I filed this brief. So addressing the issue that was sent to the parties regarding the stay, I will tell you that candidly, since the Commonwealth is stating that the certain convictions should be vacated, I'm certainly not going to stand in their way. I think they should be vacated, but I also have no issues with the stay pending the decision from the Supreme Judicial Court. Mr. Sigman was sentenced to an 18-month-ish period of incarceration. He's been out for some time, so it's not as if the actions that this court takes today or doesn't take today would result in the jail door opening. Obviously, not having a conviction on his record still matters very much, but I think there's no. I think we can take our foot off the gas in terms of waiting for the SJC case to be resolved.
Can I just focus on, there's a third charge, discharge of a weapon within 500 feet of a dwelling. He was convicted and sentenced to, I think, 3 months in prison.
Correct.
Or jail. Does that change the analysis on the stay? Because you don't need to know whether or not he
correct.
Had a license.
So, as a matter of fact, the prosecutor and I were talking about that earlier this week. That charge is still something that we need to address and something we still need to deal with. It doesn't, the stay doesn't impact it in any way, shape, or form, as Your Honor correctly said. Whether or not you have a license to carry a firearm, you can't necessarily go shooting guns within 500 feet of a dwelling,
right.
Nor should you. So yes, so that gets back to the main issue on the brief itself.
So we should talk about authentication.
Yes, Your Honor, exactly right.
And so on authentication,
yes,
I want to make sure I understand because the police officers come to the house. To be clear, I've watched the surveillance video. I understand it. It's through the little tiny camera. They go to the resident who's the tenant or owner. She shows them the video in question on her computer.
Correct.
And she gives them and so the officer sees that video.
Yes.
The original video.
Correct.
She gives him a flash drive copy of the video.
Correct.
And that's what actually gets entered into evidence.
Correct.
Right? And so he testifies at trial, to tie this all up, that there's a fair and accurate representation of the video he saw at the time in her house.
Correct.
Right?
Yes.
So what's the issue?
The issue, Your Honor, is that I have an obligation to zealously advocate on behalf of my client. This was a very brief jury waive trial, and as I started by saying this case sort of took a left turn when we started addressing the firearms issues. I've said this more than once, and I apologize for repeating myself. I don't know that I planned on being here, but for the issue of the stay. I think the argument that I put forward in the brief is an argument that I have no problem making to the court, and the issue is simply that there is a gap.
Thank you for being a zealous advocate. I appreciate
that, Your Honor.
Appreciate your candor as well.
But I do think, as I set forth in my brief, there's a gap. We don't know what that flash drive was. We are trusting the officer, and again, the judge chose to believe the officer that that the flash drive was a fair and accurate depiction of what he had seen earlier that day when he went to the woman's house and observed the video. I think that the better practice would have been to button it up a little bit more had the Commonwealth done that. I think that there were steps they could have taken that would have made this a non-arguable issue in any way, shape, or form, and they didn't.
Didn't one of the police officers, though, also testify to the defendant's admission that he was aware of the surveillance system because he installed it?
He installed the surveillance system.
So your argument standing alone may have some teeth, but with that additional corroborating evidence, it's a tougher sell, right?
Yep.
Okay. Fair enough.
I think we're all more or less on the same page here. So,
I mean, it's kind of interesting so this was going back to the first issue, this was a post-Bruin, pre-Guardado case.
Correct.
And defense counsel moved to not let the Commonwealth put on evidence that the defendant didn't have a license.
Yes.
Okay. So, I mean, I guess this is for the SJC to decide in their two cases, but.
I will say that, obviously I wasn't trial counsel. I don't know what trial counsel was. I don't know what the thought process was. I think we're all aware that, the law in the Commonwealth and the law coming down from the United States Supreme Court, there's stuff coming down every day. I'm not suggesting for a minute that trial counsel wasn't aware of those decisions. She certainly doesn't mention any of them during the course of the trial. Nothing ever comes up. I'm not sure where to go with that other than to say that the Commonwealth has correctly stated that the convictions need to be vacated, and the question is whether or not this court waits to see what happens at the SJC before issuing a decision.
Okay, and you agree we should wait?
I'm sorry?
And you agree we should wait?
I see no harm in waiting. I do agree with the Commonwealth that the remedy my client will get the remedy my client will be impacted by the decision of the SJC, despite the fact that the convictions will be vacated in the interim. Since my client's not in custody, since he's not even on probation, the difference between this court issuing a ruling in the next 6 weeks and waiting for the SJC to make a decision, and then this court issuing a ruling. Again, I suppose hypothetically, if my client was arrested for something and then these prior convictions came up, hopefully somebody would notice this issue, but we're threading a very, very small needle there, and I don't know that that's going to happen. So if there are no further questions.
One more.
Yes,
Sorry.
no problem at all, Your Honor.
At any retrial, is the issue of the authenticity of the video going to come up again? In other words, do we have to reach that issue because of the possibility of a new trial?
I suppose the answer is that if I represented this gentleman at trial, I would bring up that issue again. I think that, I think one almost has to if the Commonwealth isn't looking to, like I said, take all what I would think would be the easier, not necessarily easier, if the Commonwealth wasn't going to take the steps that they could take to literally take this issue and throw it out the window, I would make an objection to it. Whether or not the objection would sort of fall under the same category again and be sustained the same way or overruled the same way, I think it may, but nevertheless, as I indicated to Justice Wood a little while ago, I have an obligation here to make whatever arguments I can on behalf of my client. And I would do the same thing at trial.
Okay.
Thank you very much.
Thank you.
Good morning, Your Honor, and may it please the Court. Aaron Stoudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. I'll start with the authentication, which I do think the video was properly authenticated one of two ways here. As the Court noted, the officers did testify to how they retrieved the video. They got it from the person who controls the surveillance system. They testified that it was a fair and accurate representation of the video they saw on that day and the procedures that they went through to obtain the video. It was a download from the security system from the homeowner that occurred 3 hours after, I think it was 3 or 4 hours after the event, and so that independently authenticated the video. And then apart from that, the video was also authenticated by the circumstances depicted in the video, which matched almost frame for frame the defendant's own.
You said it was a few hours after?
Yeah, so the incident, the testimony is a little unclear, but it appears, based on the testimony, that the original firing occurs at around 7:50. I think it was like 7:30 in the morning. Detective Deno and Officer Sheehan then respond at around 11, and then eventually view the video at around, I believe, 11:30 is the estimate.
Because at the end of the video, which is like a half an hour, there's a police officer arrives.
Yes, that's Officer Sheehan arriving the first time. That was not in the record, though, so that is not before this court.
Okay.
But yes, outside of the record, that is Officer Sheehan arriving the first time, but he does not identify himself at trial. It would have been nice if he had. But I do think it is independently authenticated by the circumstances within the video. Like I said, they match event for event the defendant's interview that he gave to the police officers of him arriving with a friend, entering his car, the female occupant of the apartment coming out first, speaking to him out the window, him then getting out of the car, dropping the firearm, and then firing it straight in the air before spinning off on the wet ground. And I think it's very important that not only is he giving like excruciating detail of this events, but they are in the exact sequence that they occur in the video. And so I think there's no question that the video is properly authenticated. This court obviously needs to reach that issue because of the discharging a firearm charge. And if there are no further questions on the authentication.
Are you requesting a stay?
We requested a stay. I initially felt that it would be more judicially efficient to do it that way rather than return it. And I had the same thought that he's no longer in custody. But I do realize and why we're sorry.
No, go ahead.
I was going to say, while we were reviewing this after the court's order, I did realize he does have 2 convictions attached to him that were achieved in violation of due process, the 2 firearm convictions. So I think it's equally as appropriate to return it, vacate the convictions, return it to the lower court, seek the stay in the lower court so that he doesn't kind of have these 2 convictions hanging over him in the interim just in case he gets arrested again or something like that.
Do you agree with Attorney Corman's representation that the remedy his client will receive could be impacted by the SJC decision?
Yes. So so this case it was one of the cases that our office had highlighted as controlled by the Zemeni and Crowder decisions. I think this occurred 2 or 3 weeks before the Guardado 1 decision. And so the remedy available, it'll either be, and our office firmly believes that it will be a motion for new trial, and a new trial will be granted, but there is the chance that these cases get vacated, though hopefully a very slim chance, by the SJC.
That's actually, so that's an interesting thing. So are we, based on the record before us, do we vacate the conviction because of the Guardado issue, or is that not really in front of us?
I think it's apparent from the record, and this court can make a decision on any record. It wasn't raised, but I do think it's apparent from the record that these convictions were achieved without evidence of lack of licensure, which Guardado 1 at a minimum requires. And of course, the jury instructions were not provided. I think it would be a bit of a technical issue because it was a bench trial, but Guardado 1, it says even when because the jury is not instructed, it still is entitled to a new trial.
But so then, he wouldn't need to file a motion for a new trial if we said.
Yeah.
Okay.
And if there are no further questions, I could rest on my brief.
Seeing no, so I think, the Commonwealth's entitled to some thanks for actually, sua sponte raising this issue, and we also appreciate defense counsel for your advocacy and candor. So we are going to take a recess. We'll be back shortly before 11.
All rise.
24P172, which is POLITO versus Shire Pharmaceuticals.
Good morning, Your Honors. If it may please the Court, John McCann on behalf of the appellant, Dr. Vincent POLITO, here on the summary judgment dismissal of this matter, Your Honors. Your Honors, I assume that I heard your earlier cases where you've thoroughly read the briefs, and I'm going to go with that as well. So I'd like to get into the main issues of this case. Basically, the summary judgment was inappropriate in this matter simply because there was several material issues in dispute as it relates to the causation requirement regarding Mr. POLITO's termination. The case is undisputed that Mr. POLITO blew the whistle concerning serious public health violations concerning not just this state, but the United States of America. Shire is an international corporation. This case involves Vyvanse and Adderall, highly addictive drugs. And Shire's responsibility was abrogated in this case to, as the DEA requires and Massachusetts law requires, to track those drugs from cradle to grave. And they failed to do that. Mr. POLITO was brought in apparently ostensibly for another matter, but very soon after he became employed there, he was given this assignment. And from the very outset of this assignment, he received resistance. What was required by Mr. POLITO to do was he was to build a compliant system, a tracking system that required automation, a closed system to prevent fraud detection from the use of these drugs. It's very simple. There were two phases. The first phase, he noted that he received, in the first phase, he was told, this is your assignment. Was never told until later that there was a previous report that they were out of compliance with the DEA regulations.
Can I jump in?
Sure.
It seems to me the most important point about that SOM program was that he withdrew. Once they made clear that they were not going to pursue his approach, he withdrew. So that seems like a problem for you.
Sure, if that's what happened, but that's not.
Does the record,
No.
is there a disputed fact? Is that an undisputed fact?
No, it's a disputed fact.
Okay.
It's undisputed, as artfully argued by my colleagues, that he withdrew from the committee.
Sorry.
He withdrew from the committee.
It's undisputed, you said, as artfully drawn. Is it undisputed that he withdrew from the committee?
It's not undisputed that he withdrew from the committee. What is disputed was that he was removed from the assignment. It makes no sense to be taking off the assignment and stay on a committee that he is no longer a part of as it relates to the assignment he was given. The task he was given, which is very important to your question, he was given the task to bring in they brought in an outside consultant, and he was to provide them with a compliance system. They stopped that in July of 2020, after he blew the whistle with regard to what his discovery was in April, and the various other people he blew the whistle to that ignored his complaints. That very issue is substantive, and he was removed. His team was shut off. They were removed from the project. And they were also told in the record shows this, that he wasn't going to provide an additional report, like a wrap-up report. He wasn't allowed to do that. Later, they allowed him to do that, I think sometime in September, October. But he didn't resign from the project. He was removed from the project. He resigned from the committee that was basically put together with other people to discuss the stuff that he was doing. So that's a key fact, Your Honor. Thank you for picking up on that. Now, the material facts in dispute go to how many times he whistle blew. The trial court took a look at this and said, this is 16 months. It's a temporal case. That's way too long. But that's not what the law requires. The law.
You're saying it's a continuing pattern.
It's a continuing pattern.
So let me interrupt you there.
Sure.
Our review is de novo.
Yes, sir.
So we are supposed to review the same record that the trial judge reviewed, or the motion judge.
Correct.
I notice in the statement of undisputed material fact, which I don't think you included, but defense counsel included in a supplemental appendix, when you disputed a fact, or when your client disputed a fact, there is a citation to JA, the joint appendix,
Okay.
throughout. I don't see the joint appendix in the record appendix on appeal. I see portions of it, but I don't. So when we're looking to see whether a fact is truly disputed or not, we have to go see, when you say dispute or disputed, cite JA 760 to 763. The only way we can determine whether or not it's truly disputed is to find that joint appendix page. It doesn't seem that you have the joint appendix in your record appendix. Am I correct?
The joint, I think there may have been one or two typos, Your Honor, in the brief, but I don't recall that.
I do not see the
I don't
joint
recall a joint
appendix.
appendix. I don't recall the joint appendix.
The joint
From the,
appendix is-
from the motion for summary judgment?
In the motion for summary judgment,
Mm-hmm.
attached to it is a statement of undisputed material fact.
Right.
Attached to that is a joint, presumably, a joint appendix, because that is what you cite to throughout
Yes,
in the summary judgment motion.
in the summary judgment motion,
And in the
okay.
opposition, et cetera. I don't see a joint appendix in the record appendix before us on appeal. So how are we supposed to analyze that? Do you understand
I'm
my
not
question?
aware, I'm not aware of that error, Your Honor.
I'm not saying it's error. I'm just wondering, did you include the joint appendix in your record appendix?
I don't recall. I don't recall if we did. We should have, I will state that, and my recollection was that it was.
I'll ask the same question.
Sure.
So let me ask this more substantive question. Do you agree that you cite the Mole case versus UMass, which is part of the McDonnell-Douglas framework? Do you agree that that delineates the correct standards here for our review of a retaliation claim?
Yes.
Okay. And is your argument here predicated on the first prong of the test? That is, we're here to look at whether or not causation was or wasn't established, and that's a first prong analysis. Is that correct?
That's correct.
Okay, thank you.
You're welcome.
That's helpful.
So I have a question about jumping to the end. You make a lot of references to this meeting with the D.C. U.S. Attorney's Office, and I don't know how to characterize it other than on the same day your client apparently receives the termination notice. Very specifically, did you raise that issue to the trial court? In other words, did you cite that meeting with the D.C. U.S. Attorney's Office as a causal connection to the firing?
It was in our complaint. It was in our brief in summary judgment as well.
Okay, thank you.
Is there any evidence on the record that the defendants knew the exact time and date that your client was going to talk to the U.S. Attorney's Office?
No, but there is evidence on the record that they knew he was going to the U.S. Attorney's Office. There is evidence on the record that the termination that was decided on June 14th and 15th, the first termination, was decided by Ms. Bauscher, stating that she was terminating him for the reasons of, which go to the mean matter of unprofessional communications. She made a separate determination after, according to her affidavit, after reviewing additional material, not whistleblowing material. Nothing in her record had anything to do with whistleblowing. It was specifically with regard to what he did for SOM, but nothing in that record establishes that. And her supervisor stated they withheld that termination because they wanted to see if he was going to participate in an investigation.
What's wrong with that? Are you alleging that there's anything wrong with that?
No, in fact, the allegation that he refused is incorrect. because
Well,
the
we're
form...
We're familiar with the record on that. Let me ask you a different question then.
Sure.
Trying to cut through it for myself anyway. Let's assume, for my question, that they had grounds for termination as of the end of August. Really, at the time that the termination was decided by Ms. Boutet in June 14 and 15. Let's assume that they had grounds for termination. Fast forward to the end of August, and he goes to meet with the U.S. Attorney's Office. Let's assume that they knew about that, and that you can approve a causal connection, or there's a jury question about that. Does that prevent them from firing him if they, again, had grounds as of June 14, 15?
If they had proper grounds to terminate him at that time, no, I don't think so.
Okay.
I think when you look at that part of the record, though, the email between Mr. Johnson and myself stated that he was going to have until September 2nd. I responded saying, I won't be able to do that. I can do it September 4th. I sent another email because he didn't respond to that email, and there was no communication, and the next communication we received was his termination. Now, Chris Allen testified in his hearing, and in a very limited way, that they knew he was going to go to the U.S. Attorney's Office. But it gets to the point of whether or not the reasons
That's in Chris Allen's deposition?
Yes, it is.
That's actually at Record Appendix 784, lines 8 to 13, right?
Correct.
Yeah. Can you give us, I mean, is there anything more in the record that's literally two questions, or one question and one answer, and it seems incredibly important, and I couldn't find anything else in the very large record to explain what that meant. How did he know what was going on? That seems really important, but I couldn't figure it out.
Yeah, and I understand that, Your Honor, because he then invoked attorney-client privilege for the company after that question, and that's recorded in his deposition.
But am I correct that there's nothing more in the record that elucidates what he was getting
No, what he said was, that's all I'm going to say as it regarding that question.
Right.
So, and it gets to the actual reasons for the termination in the termination letter. They said we terminated him for two reasons. One, for these inappropriate communications, and two, failing to under the standard, I only have to prove one of those is false. Okay? And when you take a look at those communications, that is a summation statement on whether or not those communications were unprofessional. Because during this case, Meehan comes out, the Supreme Court says, you can't fire someone for inappropriate communications, particularly as it was in this case, when you're responding to inappropriate or false allegations. That would be the Bueller.
Right. Your opponent,
case.
I'm sure you know this, your opponent responded that you were misconstruing Meehan, that there's a statutory right in Massachusetts to address things that go into your personnel file, to make a written rebuttal to information in your personnel file pursuant to Massachusetts statutory authority. Right. And that's not at all what was going on here. What was going on here was emails back and forth, so undisputed that the emails are going back and forth, and they're saying, you seem disengaged, your pipeline is thin, come meet with me. And then he responds, they argue, in an unprofessional way. But that seems, what's your best answer that is different than Meehan?
Well, it's very different because Meehan also had an eye toward...
it's
very different than Meehan. Excuse me.
Go ahead.
Go ahead. What's different in this particular case is because Meehan articulated more than that, Your Honor. Meehan articulated that in footnote 7, very clear, the Supreme Court said, cases going forward, particularly retaliation cases and discrimination cases, which would involve retaliation, need to pay close attention to this particular case. And the facts on the record are more than just emails going back and forth. Dr. POLITO specifically states you are creating a false record for termination. Okay? The defendant, his boss, Mr. Mueller, admits to sharing that information with HR, not once but twice. First, when he created a log for October, and then the second time in January, right after he blew the whistle to the chief compliance officer. And that's critical here in terms of the facts in dispute, Your Honor. It's not that he just blew the whistle to every other every person he could find. Under the corporate integrity agreement that Shire entered for its previous violations of federal law, the chief compliance officer and the chief compliance officer alone was responsible to provide information with regard to violations of law. That was the purpose of the corporate integrity agreement. They had two chief compliance officers. As soon as he set a meeting, his boss intervened, and then she set the meeting in July, around July 20th. Then she's gone from the company, just gone.
That's 2015, right?
That's 2015.
And then he meets with Rosenbaum in January.
And he meets with Rosenbaum in January.
2016.
And it placed the duty on Dr. Polito to come forward with this information.
The red light's been going up.
I apologize.
You're past time. Don't apologize. I have a quick, if I may, follow-up question.
Me too.
Your brief focuses on count one, wrongful termination and retaliation. Am I correct that that count was brought only against Shire, not against any individual defendants? I believe the answer
I believe the answer is yes.
Okay, thank you.
I believe the answer is yes.
And so, and you don't really argue counts 3 and 5 in your brief?
Counts 3 and 5 are factually dependent upon counts 1.
So in other words, you're arguing that if we rule in your favor on count 1, counts 3 and 5 naturally follow as a matter of law. If we rule against you on count 1, counts 3 and 5 fail as a matter of law.
Correct.
Got it. Thank
Correct. You're welcome.
you.
Thank you.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors, and may it please the Court. Caroline Trusty for the appellees. This case is about an at-will employee who was terminated after he spent 6 months refusing to do his work. He also spent 6 months refusing to converse with his managers unless those conversations were recorded, and he further spent 6 months refusing to participate in an interview with the company meant to address the concerns he himself had raised. All of this conduct by Mr. Polito is undisputed, and it's undisputed in large part because Mr. Polito refused to interact with anyone at Shire unless the conversations were in writing.
So let's talk about the record before us. Do you agree that before the motion judge, there was a Rule 9A package which included the motion for summary judgment, the memo, the opposition, and the statement of material undisputed facts?
Yes, that's correct, Your Honor.
Do you further agree that the statement of material undisputed facts cites throughout to the joint appendix, and at least before that, Judge, there was a joint appendix attached?
Yes, that's correct, Your Honor.
Do we have the joint appendix before us in the record appendices? We have some subsections of it that you filed in the supplemental appendix. Do we have the joint appendix as it was presented to the trial judge in the record before us?
No, Your Honor. All of the documents that were in the joint appendix appear in the record appendix. We made sure of that. But Mr. Polito and his counsel, this is their appeal. They put together the record appendix and did not want to include the version with the joint appendix. But all of the documents cited in our brief, all of the documents that were available.
They're findable somewhere for us.
That's
So we have to try and match up JA 762 to somewhere in the record where there's JA 62, even though there is no table of contents or anything else showing us where to find that.
That's correct, Your Honor, and unfortunate, but I will say that all of the documents that were in the joint appendix before the court are in the record appendix, and our brief is particularly helpful if you're looking for a particular citation.
I've read both the briefs. I know that's fine. Let's go on to a different question, which is this. At footnote 7 of your brief, you cite to the Downey case from this court that to establish retaliation, employee must show protected activity was a but-for cause of the alleged adverse employment action. What other Massachusetts authority do you have for the proposition that the but-for causation test applies to a retaliation claim in claims involving private sector employees suing private sector employers?
So, Your Honor, just respectfully, Mr. Polito does not have a retaliation claim at issue here. His claim is a wrongful termination claim in violation of public policy. We cited the Downey case simply because the causation element from a retaliation claim, it's typically the same as
Mirrors the wrongful termination.
That's correct. And so to answer
So
your question.
okay, you've corrected my question. Let me ask it this way. What proposition do you have for a wrongful termination claim that but-for causation is the applicable test? And I want your answer to be limited to private sector employees suing private sector employers.
Your Honor, there is the Shea versus Emanuel case, and this is the Massachusetts Supreme Judicial Court, and this is where the court essentially says, this is on page 763 of that case. The record contains nothing to support the claim that the college discharged the plaintiff for a reason contrary to a well-established public policy.
Does it say but-for causation in Shea?
It doesn't say the phrase "but for causation."
Because I haven't seen it in any case outside of governmental lawsuits. I've seen some similar language. I've never seen it phrased as but for in the context of a private individual suing a private entity.
Well, Your Honor, if I can clarify what is meant by but for and what we mean by but for, we certainly don't mean to apply any higher standard than is applicable to Mr. Polito. But for just essentially means it's a motivating factor, it's the deciding factor. And you can see from a case like Shea versus Emanuel, where there's no evidence that the employee was terminated for a reason contrary to well-established public policy, then that's, as a matter of law, that plaintiff's claim should be dismissed. So the idea here is just causation means if you can't prove you were fired for that reason, which Mr. Polito cannot, then he fails to prove the element of causation. So there's not meant to be any sort of higher standard there. He can't meet the lower standard either. So there are three particular reasons for affirming the Superior Court's judgment below. The first reason, and I'll summarize those briefly, the first reason is that there's no causal connection, as we have discussed. Causal connection is required. He has no direct evidence of a causal connection. And the timing between his protected activity and his termination, 16 months later, that timing is too remote, it's too attenuated. And even if we go with his argument that he engaged in the protected activity twice, in April 2015, and then for the last time in January 2016, that timing is also too remote. The second reason for affirming the Superior Court's judgment below is that Shire's overwhelming evidence of its legitimate, non-retaliatory reasons for firing Mr. Polito, that evidence is undisputed, and it's sufficient to overcome any hypothetical inference of causation here. And there wasn't any inference of causation here.
You cite a U.S. District Court case for that, Elliott Lewis. Do you have any actually binding precedent that says that?
Well, Your Honor, I hate to keep pointing to the Shea versus Emanuel case, but that's another very helpful case from the Supreme Judicial Court where there was, first of all, no evidence of causation, which he has no evidence of causation, but also in that case, the employee had employee issues. In particular, it says the record is replete with examples of the troubles the plaintiff was having on the job. And then it goes on to say, because the employer produced unrebutted evidence that would justify the plaintiff's discharge, and the plaintiff produced no other evidence, in that case, that was sufficient to overcome any inference of causation. Additionally, the Superior Court cited the Bradley decision, and the Bradley decision was an unpublished decision by this court, where similarly, the undisputed facts about the employee's performance in that case was sufficient to overcome even the close temporal proximity in that case. Again, there is no temporal proximity in this case, and so there's no need for any evidence to overcome it.
Well, let me ask you the same question I asked your opponent, that this meeting with the D.C. U.S. Attorney's Office, I don't think, you had a footnote about this in your brief, actually, and you say there's absolutely no evidence that Shire knew about this, but I gave your opponent the citation. I think Chris Allen, I think the head lawyer for Shire, has this one question in his deposition and his one answer: I knew he was going to talk to the feds. And I would have thought there would be a whole bunch of follow-up about that, but there was zero. So what can you tell us about that?
Well, Your Honor, it is correct that there is no evidence in the record, and I think this goes to Justice Massing's question earlier. There is no evidence in the record that Shire knew when it terminated Mr. Polito that he had gone to the U.S. Attorney's Office that day. That evidence simply does not exist in the record. As you point out, the only thing in the record that exists is that Mr. Allen knew that Mr. Polito was going. There's no evidence that he knew when.
Timeline.
There's no timeline, exactly, Your Honor, and there's no reasonable inference that can be drawn from that. The court would have to infer that Shire knew a fact that it didn't actually know. The court would have to make up a fact and impute knowledge of that fact to Shire in order to draw an inference of temporal proximity from that fact.
Thank you.
So we've discussed the first two reasons, and so I'll just hit on the final reason, which is that Mr. Polito's theory in this case, as the Superior Court recognized, would redefine at-will employment in Massachusetts. Under Mr. Polito's theory, any at-will employee, no matter how insubordinate, no matter how unprofessional, any at-will employee could effectively insulate himself from termination indefinitely simply by alleging some sort of public policy issue in the workplace, some sort of public safety issue in the workplace. That's not how at-will employment is supposed to work. That's not how the public policy exception works. And that really is why the Superior Court should be affirmed below.
Although it's not like he came up with a whistleblower after he thought he was being terminated. That was right from the beginning.
So that's correct, Your Honor.
That argument might carry some weight if somebody sort of at the end made, kind of fabricated some whistleblowing activity. But his was right from, it was a theme of the employment.
Well, but the only evidence he has available here is that he blew the whistle and that 16 months later he was terminated. So if that's enough evidence for someone to get to trial, for an at-will employee to get to trial, it means that it would always be enough for an at-will employee to blow the whistle and then to 16 months later be terminated. That would gut the at-will employment doctrine. It's a very broad doctrine, and the exception is very narrow, purposefully so that the exception doesn't swallow the rule.
I have a very specific question on legitimate reasons. The move. The company says January 2015, right? Everybody, we're going from Philly to Boston or Lexington. And then at the last minute, Mr. Polito says, is there any movement there? I don't want to go. And then that's January. And then February, he gets the doctor's note saying he can't come into the office. My question very specifically is, did he ever move to Lexington or to the Massachusetts area, or was he... does the record tell us that he did not move to Lexington? And I'm not trying to hide the ball. I'm trying to see if there's an inference that this doctor's note is essentially his way of avoiding moving from Pennsylvania to Massachusetts. I couldn't quite tell if the record supported that in an undisputed way.
So, Your Honor, I think that would be a reasonable inference, but respectfully, I don't think it's necessary here because the reasons he was terminated, they're in the record and they're very explicit. The reasons he was terminated wasn't because he was reluctant to move. Of course, that was sort of the context around it. But specifically, Volume 1, page 265 of the record is his termination letter. And there it indicates he was terminated for, quote, as a result of the increasingly antagonistic and unprofessional nature of his communications and relationship with his manager. So I think that would be a reasonable inference, but it's not necessary because it's clear from everything you can see in the record, from the communications, which we cite in our brief, and I'm happy to provide more examples if needed.
He disputes at least that it was antagonistic in the statement of undisputed fact.
Well, his dispute is also not relevant for a few reasons. First, because I think it's on its face, his communications are unprofessional. And I can just give you, there are several examples in the record.
We've read the record. We don't need it.
Okay, sounds good. Well, the several examples in the record, they're unprofessional on its face. But even if they weren't, Shire only has the burden of production here. Shire doesn't have the burden to persuade the jury that Mr. Polito was, in fact, unprofessional. Shire just has to articulate its reasons, its legitimate, non-retaliatory reasons with some support. And then it's Mr. Polito's burden to prove that those weren't genuinely the reasons. So the question of whether he was in fact unprofessional, it's not relevant. The question is whether he was fired in fact for the reasons that Shire says he was fired. And again, just to get back to the burden shifting framework, that question isn't even relevant because he doesn't clear the first hurdle, which is proving some causal connection between.
That was actually my question. Do you agree with your brother that this case, at least initially, largely hinges on the first prong?
Of causation, is that?
Yes.
Yes, he has to prove causation.
And that's a first prong analysis in the first instance.
Yes, Your Honor, it's a first step analysis because he has no direct evidence of
I call it
causation.
first prong, right? First step in the three-step McDonnell-Douglas.
Yes, that's correct. So one other thing I'd like to address, because my brother counsel indicated that, he said it both ways. He said that Mr. Polito did not resign. It is undisputed that he did resign from the SOM committee. That is in the first volume of the record on page 208. That's undisputed. It's also undisputed that he was not removed from the project. It's undisputed that he was invited. Shire decided to go with an external third-party provider. It's undisputed that Mr. Polito was invited to that meeting and he declined to attend. That's undisputed it's in volume 4 of the record on page 167. So because Justice Wood asked in particular about that question, I wanted to clarify the record there. And I guess I'll just end with, unless there are further questions, I will end because the Superior Court put it better than I could. This is page 71 of the addendum to our brief, the Superior Court. The court recognized that an at-will employee who blows the whistle gains protection from discharge in violation of a public policy, but that protection does not forever insulate the employee from termination. Employers may still demand a satisfactory job performance and compliance with internal policies. And this is the important part. To rule otherwise would warp beyond recognition the concept of the employment at will doctrine, contrary to the narrow exception intended. If there are no further questions, I will rest on the brief.
Well,
Thank you very much, Your Honors.
Thank you both. Very helpful arguments. And the case is submitted. And our last one for today is DOE number 461415 versus Sex Offender Registry Board. See a couple of familiar faces here. Yeah, good morning.
Good morning. May I proceed? May it please the court. Attorney Fred Burkholder for John Doe, 461415. I usually don't get cases like this, so it was a pleasure to get involved in it. I would like to take credit for the original argument that was made at the hearing level, but that was done by someone brighter than I. But that said, it's an interesting argument, and it's something that's not been addressed. My brother and I were talking before we came in, and I said, you know, I don't think they addressed it in the proposed regulations that are coming out, that are being circulated as we speak. That's not in the record, so I don't want to go into it, other than to say it seems to be an issue that nobody wants to take a grasp on, but it's real, and it's there. And it's simply that individuals of Latino descent, very little's been done with regards to their particular circumstances and how they equate to risk of reoffense. And yet we apply these regulations and say, this is what we can do. That's why I did the research, or not the research, but the discovery at the Superior Court level to say, let's see what it is. And I went through them, and I was shocked to find what I found, which is represented in the brief. Six of the studies out of the pile that they provided to me even referenced what, you know, the data was and what the sample size or the demographics.
Can I just make sure I understand the argument? I think that you're saying the argument is we don't know whether or how someone's Latino background affects their recidivism rate.
Yes.
Okay, so it's fair to say that we would be speculating about the notion that Latino background is relevant at all?
No.
Okay, so why not?
Because if you look at the studies that I did provide, or that were provided at the hearing level, there are only two, but they are relevant in that one says, if you look at the static 99 results that have been obtained as a result of application of the existing actuarial result on Latinos, the results don't correspond with and match up with what they have for Caucasians or for blacks. They just don't match up. That's the first problem. The second problem is, in the other study, this very glaring statement stuck out to me, and I cited it in my brief. Even the Superior Court picked up on it and said, that's in essence my argument. Well, sure it is. And it says, this is at page 71 of the third exhibit file, and it's contained in study that's at number 11, or exhibit number 11, and it says, data used in the development of tools to predict recidivism lack the racial and ethnic diversity that characterizes the U.S. population, which may explain the decreased ability of the static 99 to predict sexual recidivism for Latinos compared with whites who have committed sexual offenses. So I've got evidence that says there is the problem.
But you also have, I'm sorry, but you also have, first of all, briefs is very interesting, and your briefs always are well-written and interesting, so we appreciate that. But having read Exhibits 11 and 12, they also both say, and I'm paraphrasing, but in effect, at the end of the day, there's just not that much data out there and more studies are needed. They don't really come to conclusions. They say there's some data that sort of supports some ideas here. Isn't that a fatal shortcoming to your argument?
That is my argument. That's why I want an expert. Because there's simply not enough evidence to make an empirical finding.
So on that, I'm sorry if I can jump in. So you wanted Dr. Brown, you want funding, or not you, but you're...
I'm sorry, I didn't hear you, sir.
You want funding for an expert. Is the expert, what is the purpose of this expert? Is it to do meta-analysis, or to a survey of the research, or is it to do the original research itself?
Or third, or is it to say that because my client is Latino, it applies differently?
All of the above. And I'll tell you why. Because this issue's not going away. And sooner or later, the SJC is going to look at it and say, you know, it's something we need to address. And then the next question we're going to hear is, where's the Daubert analysis? So therefore, if an expert's going to get up, somebody's going to have to qualify him. And when you qualify him, obviously, the Daubert analysis is going to say, on which do you base this? So it's a significant issue for a significant portion of our population that's growing.
Let me ask a different question. The two areas that you suggest are analogous are age and gender. And I think, from my understanding of your brief, that in both instances, the petitioners were able to cite studies which demonstrated that these factors did have an effect on recidivism. Gender, women had a lower recidivism rate, and age, I could be wrong, but that older people, the age crime curve, that the older people are, the less likely they are to recidivate. But the crucial point was that there is data, and those petitioners both said, look, there's already research on this, that it affects recidivism, and the regs don't address this at all. Whereas here, we have this gossamer thread of a possibility that maybe Latino origin is relevant to recidivism. Have I got that right?
No.
Okay.
Here's why. It's the first time I've had the privilege of appearing before you.
Go ahead.
Whatever. That said, so if you look at 151564, this is what the relevant paragraph is, and I'll be brief. The SGC explained that although Doe had not presented any specific research demonstrating that any particular factor currently included in the regulations is now considered unreliable within the scientific community, and had not suggested that any more recent research has established that any of the included risk factors are no longer relevant or reliable as a determination of the risk of reoffense, there was substantial evidence presented at the hearing authored by the same researchers on which the board relied in developing the current regulations concerning the importance of age, something the board did not think of as a factor in its regulations. So my point is this. Nobody's talked about it. It's not referenced in the statute. It's not referenced in the guidelines. It's just like, let's not bother. Well, you know, there's a significant portion of the population out there that says, I think we should. And if you look at the studies that I did submit, there are some differences that are noted. And I'll tell you why it's relevant to this case. In the treatment records for my client, one of the things that he was praised for was his recognition of the existence of beliefs that were different and acting upon those beliefs. And that's something that you'll see in representation of Latinos. I've had other cases where this has come out, where I had a client where providing ritual baths was something that was accepted within the Latino culture. So my point is this, it's there are differences, and also, you know, they look at it, the studies also look at whether criminal contact has as much significance as it does otherwise, whether they're prone to offend against intrafamiliar versus other offenders, what's their social economic class, i.e. education and the like. So there's a lot of factors here that supposedly our regulations say, yeah. I don't think so.
I'm trying to understand how, if we gave you what you wanted and we remanded this and I guess ordered the court to give you funds, how many, I still don't quite understand. You said, we asked you, what do you want your expert to do? And you said all of those things.
Basically, I think they've got to be able to, somebody's got to undertake the analysis that the board should have done when they drafted these regulations and do a meta-analysis, take a look, and I don't think it's going to take long because there's very little that's been done. And
wait, sorry, slow down. I think you just answered a meta-analysis. You're asking the first step would be a meta-analysis.
Well, and
that's of scholarship that already exists.
Not necessarily, because there's been very little done, and that's what everybody acknowledges.
So meta-analysis would not be helpful.
Well, I mean, in meta-analysis, in my understanding of its definition, is to look at the existing studies.
Right.
So if there's two, all right? And maybe by that they say, okay, this is what we have. Then I think due process requires that this individual be given a thorough evaluation, static 99R not be included, and that's one thing, I mention that only to say this. Much is to be made in my brother's brief about, well, there's no factor that's affected. How about factor 35? I mean, it was applied because he had a 4 or 2 on the static 99R, and as a result of the combination with the stable 2007, average risk categories where he was placed. But the study that I submitted clearly says it's not valid for Latinos.
Let me ask
So I think in and of itself, factor 35 has to go.
Let me ask a procedural question. Would you agree that the written motion for expert funds that was submitted in this case was not the race-based issue that was argued before the hearing examiner?
Absolutely.
Okay. So your predecessor counsel came in and filed this motion earlier, and then on the day of the hearing makes an oral motion for an expert on Latino, the relationship between Latino offenders and the factors or something to that effect, correct?
Predictability of the application of the factors.
And submits 2 articles.
Yes.
Where in that oral motion did predecessor counsel identify the particular type of expert witness that was needed? Okay, thank you.
So, I mean, there's been a lot of mistakes that have been made in this case.
I'm sorry, that's the request for expert, and then you develop it more in the Superior Court.
Correct.
And in the Superior Court, it's more like a challenge of the regulation as opposed to a request for an expert, right?
Superior Court just blew it off completely. Superior Court said, listen, there's been 2 challenges that have been based upon this. One is a declaratory action. One has been a 30A-14. Under a 30A-14, all I have to do is look at the record. Even though my opponent brother at that hearing stipulated the admissibility of the new studies and the chronological study, he ignored them. Because they say, I mean, that's the most evidence you're ever going to get, which says, show me how these regulations are based upon studies or data that in fact is empirically accurate toward everybody. They're just not. I was shocked when I read them.
So, I mean, so what, in the end, can your, if we follow your theory to the end, can your client be classified at all?
It's a very good question, and I guess what we're going to find is almost a 22188 argument, which is, let's take out the factors that we can't apply because we don't know, and then we can at least apply the ones that we have, and those are not characteristic of his demographics or his background, and they're more based on simply what we're not supposed to look at, which is just the nature of his offense. That I think you can do. And frankly, to be honest with you, and based upon the nature of the offense, it's certainly not a no registration case. I'm never trying to say that. I'm trying to say, and it may even be a level 2 at this point, but very soon it's not going to be, because he got released in 21, so he's going to have 5 years out in the community very quickly, and somebody's going to have to look and say he didn't do anything wrong. Now what do we do? And that's kind of where we are in this case. That's why I liked it, because for a change, this isn't just to apply to me, and I never get assigned to cases that are of this importance. I mean, mine are not. So that said, I mean, and I'm not speaking. It's just I'm not a constitutional lawyer. But the argument I think is here, and I think between what was submitted at the hearing level and what I was able to get from the board themselves, I think there's a basis to say somebody needs to look at this, because I don't think there's an empirical basis, and at the very least, I think it needs to go back, and an expert tries to figure out how to get up enough evidence that will survive this Daubert challenge, and we can go forward. I have nothing further.
Okay, thank you.
Thank you.
If it pleases the court, David Shania for the board. I think the governor's office would be surprised to find that we might be talking about funding a meta-analysis through expert funds. I don't think that's the job of the SORB, nor is it the job of the governor of Massachusetts. The board takes the analysis of research that's given to them to make, or that has been done by others, experts in the field, to make the regulations. One of the things you have to remember, when in 2006, when the first regulations that were validated by the state or allowed by the state were put into place, it said female and male offenders, that the regulations applied equally to both. And by 2014, a large body of research came out that showed that female sex offenders actually had different characteristics when it came to determining sex offender recidivism. And part of the problem prior to 2006 was there weren't that many female sex offenders, because at the time, for a number of reasons, one of which many female sex offenders weren't prosecuted in the 70s and 80s. And another issue was that they weren't considered to be serious sex offenders in research circles. So prior to 2006, there wasn't a whole lot of data about female sex offenders. And the majority of female sex offenders you got were ones who were co-defendants with or co-conspirators with male sex offenders, or were part of their sex offending behaviors on others. So when that research came out by 205614, which I argued in the Supreme Court unsuccessfully on behalf of the board, it was clear that the board needed to update regulations to put factors in for female sex offenders. The same thing happened with age. For the longest time, the board didn't recognize age as an issue, and then studies started popping up. And the first Doe 15164, the court said, was Judge Kafka in this court when he was Chief Justice, said, these studies are getting more prevalent. The board doesn't have a regulation that covers this. If these studies are in evidence and the individual is of the age that these studies refer to, the hearing examiner has to consider it. And at that point, the board started developing a regulation based on that research.
Is the substance of your argument essentially that this is speculative until there is a more robust data and studies are issued?
Correct. I mean, if you do a meta-analysis now, you have two studies. to meta-analyze. I mean, I don't think you need a meta-analysis. When you have a meta-analysis, you usually have 8, 9, 10 studies that they're done trying to coordinate all of the information that's been gathered.
Well, these two studies essentially conclude, and again, I'm paraphrasing, but essentially conclude, we think there's something there, but more data and more studies are needed.
Correct. I mean, the board's position is these two studies alone aren't sufficient for the board to have to change its regulations or to change its classification process as it applies to Latinos. And the studies themselves specifically point out the numerous problems that they have gathering the information, such as the fact that a lot of the information was, like I think the second study talks about the fact that it may not be applicable to the full characteristics of the Latino community in the whole United States because it was a Northeast study. Another part of it says that you're depending on Department of Correction records, so we don't have a full glimpse of how much sex offending is going on in the Latino community. Also says that because they tend to be more intrafamilial, they believe a majority or a lot of them haven't been reported. So it's hard to make that judgment on these two studies that the board's regulations are inapplicable to.
I can interrupt you right there.
Sure.
How much data, how much information is needed? And by that I mean this. Is it when there are some peer-reviewed studies that have an ultimate conclusion that Latino offenders are different than Caucasian offenders on the whole, and here's why? Is it when Hansen says so? I mean, at what point do we say, yes, you're right, and you get an expert?
I think it's when you start getting a number of studies that are coming to the same conclusions. And in this case, in fact, the second study specifically says there's not enough empirical evidence at this point to say that the static 99 or any other characteristics of Latino offenders are definitive because of lack of information that they have in the records that they've been able to obtain. I mean, I thought it was really interesting that they also found differences between different types of Latino communities, and that their big concern was those coming from Latin America and South America, we couldn't get their criminal records or their background information. So that limits their ability to take those people's characteristics into account, their historical characteristics or their static characteristics. So the board's position is that, granted, there may be something there. It may have to be developed much further in the future. It may be something that the board someday will have to reckon with, but these two studies don't put us there now. And that's essentially the board's argument on this.
So, but how about his argument that let's distill it. So there is something there, and give me $4,000 so I can have somebody maybe try to explain to the board what the differences might be.
I think what that individual is going to do is, I guess, read the two studies and then analyze this individual and see if he fits within the categories of the studies. I don't know what else this expert's going to base his decision-making on. Unless he himself has done his own meta-analysis, which I doubt has happened, because the last study we got is now 6 years old.
I mean, what if he had some information about interfamilial, relationships?
Well, keep in mind, if a sex offender, Latino sex offenders tend to be intrafamilial, actually it's a benefit to them because the board finds that intrafamilial sex offenders are less likely to reoffend than extrafamilial. So it's not like they're penalized for that category.
And I forget in this record, was the victim considered extra, or I mean, she's like
extrafamilial, but she was the girlfriend's daughter. They were not biologically
Actually, I think it was the girlfriend's niece.
Right, sorry.
And more
not
important,
biologically related, though.
right. And in the second study said, they generally don't have a violent criminal background, but this individual has a violent criminal background with 2 assault and battery.
My same question, but do you have any concept? Does the record support any inferences about what an effective study would look like here? It seems like it really would be a demographic study of a large, reliable data set of people that are analogous to the subcommunities of Latinos. In other words, what I'm getting at is there any universe in which giving $4,000 to one guy is going to begin to answer any of these questions in a meaningful statistical way?
Not unless he does his own research, which again isn't the state's prerogative to support research work through the Sex Offender Registry Board. Otherwise, again, there's just not enough information out there. You know, one of the very first studies that the board looked at back in 2006 started with a study, I think it was out of the criminal justice system, of 4,000 sex offenders. So you're looking for large numbers. Hansen, if you look at his studies, takes large numbers of individuals at given times, and then does, after putting out 2 or 3 studies, then does a meta-analysis of those studies and other studies that are being simultaneously done. He'll look at Letourneau's studies, he'll look at other individuals like Boutet's studies, and he'll consolidate those into his findings to try to find an average mean of characteristics, traits, or recidivism rates. If you look at his most recent desistance studies, it's not just him, it's a number of studies that he's incorporating into that to try to get an understanding of what everybody's finding and what's coming together on a whole. So I think that's what you're looking for, not just 2 separate studies, one from 2013 that says we're basically the first study ever done in this area, and 2017, which was 5 years old by the time of the hearing examiner even had the case. So I think I've really nailed these issues down to try to explain the board's position. Unless there's any specific questions that you have, I'd be more than happy to rest on what I've written.
All set.
Thank you.
Thank you both. A really interesting case. Oh, one question. Are there new regs out for public comment?
My understanding was that part's been done. It was supposed to issue at the end of January, and CPCS requested to hold it up to look into it again, and then now it's on hold again. That's my understanding of what's happened up to this point.
Okay. Thank you.
Thank you.
Thank you.
I want to thank the court officers, thank the clerk, and we are in recess.